a good lawyer. And the legal aid system is, as I said, quite poor. NALSA has issued instructions that legal aid should be provided to people who are excluded from the NRC process. I mean, we haven't seen much implementation of that, but that is what is critical. I mean, if you have a good lawyer who can help you obtain the documents, who can tell you how to be a good witness, who can coach you, that is what is critical to be able to navigate the system, and that is what a lot of people really lack. In terms of due process and how I would feel again that the processes in the foreigners tribunal, these are not secrets. I mean, we didn't have to go in with a hidden camera. Everyone in Assam knows what is happening. And even when these cases are going on appeal to the high court judgments seem as arbitrary as the foreigners tribunal judgments. So I'm not really sure what can be done. Maybe the Supreme Court, but I don't know. But the argument again is that this NRC process is being monitored by the Supreme Court. So I'm
No.
really not sure what the answer is.
Yeah, there was one question at the back there, and we'll take one question here. Oh, sorry, sure. I'll come to this side after these two questions.
My name is Aditya Falnikar. I'm from the National Law School. So one comfort that I think all of us here are taking is that the courts are taking an are taking a liberal stance, that they're allowing, they're pro-migrants. So although that's not a bad thing, my question is that is this expansive interpretation in any way weakening the doctrine of precedent? And is it, since there are multiple courts and multiple courts are delivering judgments, is it also reducing certainty in the law?
Okay, there was one other question.
Good evening. I'm Shantanu from NLS Bangalore. And my question is primarily to Leah, or Arijit can also address it. I agree that Amnesty International and Government of India is not on the same page on certain issues. Might be the government is having the political capital and some other issues at the back of the mind. But the point is, when Amnesty is making an advocacy, and the advocacy is not for the citizenship right, the advocacy, if it is primarily focusing on the rights approach, the basic human rights approach, I think that the government of India, even if it is having some different political agenda, can be more sensitive to the concerns of the, not only the human rights organization like Amnesty, but those detainees in general. I will give an example. Like Belgium, we see a lot of community detention camp. So the conditions are not that cramped the way you are showing in documentaries. I have heard about certain countries where the detainees, they are generally having an electronic surveillance in form of ankle caps. So basically the human rights are being restored even if the conditions are just like a prison. So if Amnesty or some other organizations which are at the forefront, if they just alter their approach and the advocacy is primarily towards the basic human rights approach, whatever agenda any government, this government or the other government that might come, they have, don't you think that the government can be more sensitive about the concerns if we are just focusing on the human rights issue rather than the citizenship issue and not taking any communal tinge to it?
Okay.
So just to answer your question, I mean, we have not taken any communal tinge to it. We look at it only from a human rights approach and human rights for all human beings. So we are talking about the process by which people are sent to foreigners tribunals and then sent to detention centers, and how that is unfair and that is arbitrary. And interestingly, the non-custodial alternatives are actually in the Foreigners Act itself. It's just that tribunal members think of detention as being the default option. So of course, we have advocated that the non-custodial options should be explored before people are sent into detention centers. The question about expansive interpretation, actually what we are seeing in Assam is not an expansive interpretation. It's quite a strict interpretation of who is a citizen and what documents are needed to prove citizenship.
In fact, in Assam, the Assam government in a white paper in 2012, I think, said that we have to ensure that we send all these people to detention centers so that they do not vanish.
Sorry, there were questions on this side, one, And somebody else had a question? Yeah, the person behind. You can just get the mics there.
Good evening. I'm Aditya Krishna from NLS. You talked about the movement of people to countries which have high opportunities, which would go on till the whole thing is balanced out. Uh, could you please shed some light on on this with the Indian context and the global context, if possible, especially with reference to Africa and the Europe?
Okay. There was a person behind. What a question.
Good evening. My name is Bihan. My question is specifically to Leah ma'am. So ma'am, we were talking about reverse onus clauses, and I wanted to know what are the problems one faces while proving his or her own citizenship. So if you kindly could shed some light on that.
I think maybe Harish, the first question I think was for on something the point that you had.
I mean, I don't have an answer. I mean, I was giving a broad context to migration as an issue in the last 78 years after the after the post-colonial period that has seen a lot of migration. That is not necessarily something that the colonizers, the old colonizers, are happy with. There's been a lot of migration before that. If you look at the number of Indians who are settled down in various parts of the world, they went as indentured labor. I mean, this has happened in our country. It's happened in the last 300 years, right? You look at Mauritius, you look at the West Indies, you look at Malaysia, you look at all parts of the world where and every now and then I come across countries where I didn't even think that Indians had ventured before, and they've been there for like 200 years. So that was forced movement of labor, again because they needed labor, and capital was forcing them to move. So, and if you look at the African American population in the U.S. as well, I mean that's part of slave trade. So the movement, it's always been economically driven, right? Now there could be other reasons for movement, right? Based on religion is what we are hearing now. You're moving for religion. In our context, in India, within the country, we are facing a lot of migration, right? People from different parts of North India moving to Maharashtra. Well, people from earlier, I'm not sure how many of you are aware that originally the Shiv Sena actually was targeting South Indians, and then they moved their attention to North Indians, right? And I'm sure they'll find somebody else, or not just that party, any other political party, right? And now in South India also there is, and Arijit was talking about it briefly earlier. Even in Bangalore there will be some resentment now that Bangalore is a city that is attracting a lot of migration. There will be a lot of issues, right? Now issues will arise when you forget that people who come are not just their economic unit, they're beyond that, right? And it generates a lot of tension when there is a clash of approach to how you live your life. Within the country, it's less of an issue because the law is very clear. You have the right to freedom of movement. Across countries, it's complicated because the sovereignty of each country is recognized. But when the demand is for free flow of capital, which is essentially to exploit resources in different parts of the world, the question that necessarily follows that is, shouldn't there also be a free flow of movement of people? It can't just be a one-way street, right? In the context of, just a point closer home to all of you young lawyers, there's a lot of debate about foreign law firms in India, right? Where, the question is, why should there be foreign law firms, right? If you ask about it, what will an American, a New York qualified lawyer do in India? I mean, if he's willing to go and argue in the, foreigners tribunals, I think we should welcome them all. But, there's a problem, right? But then essentially that is nothing but free flow of capital. It's not really free flow of people, because even they're asking for name and to set up their offices. They will hire Indians. Okay, 1 or 2 foreigners may come, but they'll hire Indians. Now the question that many people who oppose that, I mean, apart from that, it's a complicated issue, but I'm simplifying it to give you a contrast. You're not able to go and get work freely in the US. You need a work permit, and you may not get it. Correct? So while they insist on free flow of capital, free flow of labor is not easy. And all these issues that arise after migration is a problem because of free flow of people, not because of free flow of capital.
Yeah, I think there was one other question at the back.
Yeah, so this is about the burden of proof. So, I mean, since you're law students, you all know that in criminal trials, the burden of proof is on the state, and this stems from the presumption of innocence. So the person is presumed innocent till he's proven guilty. Strictly speaking, as I said, foreigners tribunal proceedings are not criminal proceedings, but the thing is that the consequence is loss of liberty. So there is a penal consequence. So actually it is quite unfair that the burden of proof in these cases is on the accused person. So what happens is, the presumption is that you are a foreigner unless you produce the documents which are original, certified, without any spelling mistakes, to prove that you are an Indian. So like this Rahima Bibi's case, I mean, because her documents were all photocopies, she was declared as a foreigner. So the reversal of this burden of proof actually is quite an unfair aspect of this whole process.
Okay. I'm afraid we are sort of almost out of time. We have only about 5 minutes left. So what I'll do is I'll just ask all the panelists if they could sort of sum up their thoughts on what we have discussed so far in about a couple of minutes, and we can then close this session. So Leah, if you could just.
So, I mean, in closing, there's just one thing we haven't discussed at all. I thought I'll just bring that up. The Section 6A of the Citizenship Act creates a separate citizenship regime for Assam. It's different from what is applicable to the rest of India. And that is being challenged in the Supreme Court. So one question that I always had in my mind was that the NRC process actually should not have been started unless that question was decided. So of course, but it wasn't stayed by the Supreme Court. So both cases are being heard by the Supreme Court simultaneously. That I think was quite an anomaly. I mean, because if Section 6A is struck down, the entire NRC process goes for a toss. So something to keep in mind.
I think one thing we should keep in mind in terms of if you're going ahead with this process, that more time should be given to people who for claims and objections. So for them to produce documents so quickly, even after this extension, it's very, very difficult, because government officials often are not really helpful. So this is something which the government of Assam could perhaps do.
Oh, okay.
Don't have anything much to add. Thank you.
Okay. Let me sort of offer some concluding thoughts on the basis of what we have discussed so far. And really what comes through from our discussion over the last 2 hours and a bit is that what we are seeing in the context of the NRC and in the context of the Citizenship Amendment Bill, there is a very pure local context to it. There is a pure national but there is a larger national context to it. And more importantly, there is also a global context to it. That if we see this through in just any one of these lenses, we will probably not get the full picture. That when we talk about issues of citizenship in India, and especially in the context of the NRC, we are not just talking about, to shift the focus a little bit to the government, we're not just talking about what the government does and what the court does as two separate streams, but they are feeding into each other. And what they are doing is not just something that they're doing only in the context of immigration or only in the context of the NRC. What we are seeing is a reflection of larger trends which have been playing out over decades. Whether it's in terms of the political process, sort of saying, okay, we will accept these certain baselines, this certain assumptions when it comes to the Assam, when they sort of negotiate the Assam Accord, that we will reflect this in the law. We need to keep all of this in mind. We need to say that, we need to understand that these are the processes which have led to this problem. When we see that the Supreme Court is sort of monitoring the NRC process, we just can't start from the date on which this litigation began, or when just the case picked up steam. You also have to see it in the context of the larger dysfunctions that the judiciary is undergoing in India. That this case is a manifestation of that, and not some extraordinary aberration which we are seeing. And thirdly, what we are also seeing is when it comes down to the ground level itself, what we think of as the Indian state doesn't seem to have much clue what it is doing. That you have no idea about the implications of your actions. You don't follow the rules that are laid down for you. You don't understand the impact of your actions. And yet you proceed to try and say, we'll have more foreigner tribunals, or we'll have more detentions. When in reality, these are still an attempt to try and fix a problem without understanding the nature of the problem, without understanding that the larger issue of immigration and the larger issue of the rights of refugees require serious political engagement with the society, with political parties, and so on, before you arrive at a solution. So, to conclude, therefore, in the context of citizenship, or rather citizenship in the context of courts and refugees in India, we have to understand that there's no simple lens through which to see this issue. It is complicated. It does not have an easy solution, and it is something that we are going to be grappling with for many years to come. And if we accept and sort of embrace this complexity, only then will we have any chance of finding some sort of an acceptable solution to the current state of affairs. Because the current state of affairs are simply unsustainable, and we are heading for disaster if we don't see where this is taking us. So, to sum up, thank you once again for being here. Thank you for participating in the discussion. And I'd like to thank all my panelists. So please give them a round of applause. Thank you once again.
Dear all, before I give my vote of thanks on behalf of the National Law School of India Review, I would like to mention that a symposium of this scale and this size and on an area of public law would not have been possible without the generous support of our alumni, especially Dr. Narsappa and Mr. Vijay Samamurthy, who couldn't be here today with us. The third session dealt with and spoke about rigid and hard borders. But today I think through the discussion and deliberation, we have expanded the boundaries and the borders of the law. And that is a task and a duty that the National Law School of India has taken upon itself, being one of the oldest student-run law journals in the country. So I just hope that our partnership with Samvad partners as well as Lexogen continues. And on that note, I would like to invite the founder of Samvad, Dr. Narsappa, to come and share a few words. We value our partnership with Samvad and are extremely grateful that you could participate with us in this inaugural session, an inaugural symposium of ours together. I only hope that this relationship of ours lasts for many years and perhaps even decades to come. And sir, the floor is all yours.
Can I speak from here?
Yeah, please.
But even I hope it can continue, because I was worried about what Leah said, that we are facing an economic recession. So let's hope that the economic recession doesn't affect what we have agreed to support the NLSIR symposiums. My congratulations to Sharon and all the other editorial team at to be honest, when we received these emails, the first time I received this email for help, I just ignored it. A second time, I ignored it again, and I think they were very persistent. So they wrote the third time, and then I thought, okay, they have a problem, because if they're writing the third time and are still looking for money, then they haven't got any. And for a brief moment, I sort of, maybe it was a really weak moment, a weak and brief moment, when I remembered all the trouble I had when I was organizing an event, all those many years ago at NLS. And since I sort of already disclosed my age earlier, so it was in the very early years when, we were all struggling to organize events. We certainly didn't harbor any dreams of organizing anything in a 5-star hotel. So I thought, and then I spoke to other partners at Samvad, some of whom are also the alumni of NLS, and from some other universities, representatives of whom are here. And we thought we should support something like that. And two reasons, and I would like to spend some time explaining those reasons. One,